Thank you, Mr. Chairman. I thank the Chairman for holding this hearing. I'd point out, as I observed the first four witnesses, they were all Republicans, and I'd also observed that likely there was an offer made to the minority party to bring a member forward that might have had some legislation to protect this Constitution, but I'm sure they would have voiced that concern if they'd had someone to offer. But here is, as I listen to each of the presenters of the members who have drafted legislation to fix this issue, I was engaged by each one of their testimony and their presentation, but when I got down to the end of it, I had to kind of do an exhale of despair because it circled back around to Congress passes another law that tells the President to now follow and obey a new law. And so it should be obvious to all of us by now that there is unlikely any law that we could possibly pass here in Congress that's going to compel the President to enforce it unless it's to his political interest to do so. And I will say that's one thing that we can count on the President to do with regard to keeping the portions of his oath, and that is if it's in his political interest and his philosophical interest, he'll enforce it. If it's not, then he'll look at the consequences, which might be a public pushback of great enough magnitude that it could be embarrassing. I'd take one of those points would be when in Obamacare, the conscience protection didn't adequately protect, especially the Catholic Church, but our religious institutions, and he was compelling them to provide contraceptives, abortifacients, and sterilizations, which was a direct violation of the principles of not the Catholic Church, but many other religious institutions, and individuals should have the same, stand in the same shoes, by the way. And so the President did a press conference on noon on a Friday, and he said, well, now I'm going to make an accommodation to the religious institutions, and I'm now going to require the insurance companies instead to provide these services, he called them services, for free. He repeated himself, for free. And if you scoured the rule that was written by Sebelius's HHS, there wasn't a letter changed in that rule. The President had spoken orally in a press conference, and the insurance companies lined up to do his will and his bidding. That was a chilling thing to witness as a sworn oath to protect the Constitution member of Congress. So, all of this that we might do to pass legislation is not the answer. Things we might do to cut off funding leaves us vulnerable to, intra-departmental transfers of appropriations or even interdepartmental transfers of appropriations. The threshold is the patience of the public. And now we're talking about going to court and figuring out how to get standing because maybe Article 3 will save us. Well, they're the creatures of Congress. We could abolish them, I suppose, if they don't do the will and the bidding of Congress, everybody but the Supreme Court. But in the end, what if the President has the same level of disrespect for Article 3 as he does for Article 1? What if he wraps himself in the cloak of, I have spoken, and there's nothing you can do about it? And so, and we have used the I word here, and we know that it's an impractical tool in this room. I wasn't a member of Congress, but I know exactly where I sat back there behind David Shippers when he delivered the summary of the prosecution in the impeachment of Bill Clinton. And it went over to the United States Senate where we didn't get constitutional justice out of the Senate. What we got instead was one vote that wrapped up all questions of whatever kind of violations the President might have had, and then into that question was, should he be removed from office? We have Harry Reid as a shield in the Senate, so now all of these provisions that our Founding Fathers have laid out, if they did anticipate the circumstances we're in, they could neither come up with a solution that they could write into the Constitution to offer to us. So I want to ask this question and go down the line first with Professor Turley, and that is, if the President shows the same level of disrespect for the judicial branch as he does for the legislative branch of our government and refuses to abide by a court, should we grant ourselves standing and somehow maybe overturn the veto of a President that would refuse to give us standing, what next is our recourse? And I think that's the question we should ask. We leap to that. I know we're linear thinkers here, but we need to leap to what's our recourse if the legislative and the judicial branch of government are disrespected to an equal level, and the President's wrapped completely in the cloak of, I am President, therefore I can do what I want.
Well, what you're describing would be tyranny if it went that far, and we do have, then we would have issues of removal. But I do think that you have avenues in which you can pursue. I compliment those that are focusing on standing and focusing, for example, on litigation abandonment issues of defending statutes. I don't believe that the book is closed on member standing, and I don't agree that it is so clear that members do not have standing. Having litigated this issue for members, I think there is room that can be expanded upon. That's the reason I think these are good ideas. But when you're talking about, well, what happens if all the safeties go off?
Yep.
Do we have this sort of meltdown? And the answer is that the framers, I think, assumed that there would always be two branches aggrieved by any aggregation of power in a third branch. That in the desperation of the separation of powers, you find alliances. What I think they never anticipated was the degree to which the judicial branch would be absent without constitutional leave on this issue. But I'm hoping that that will change.
Thank you. Professor Schroeder? Mr. Schroeder?
Congressman, thank you. As you can imagine, I part company with you at the articulation of the problem. I think if you look at the President's actions that are being controverted one by one, you will see that each and every one of them is justified argumentatively by application of statutory law. So I don't accept the proposition that the President is disrespecting this body. He came into office trying to distance himself from President Bush, who did say on some notable national security-related questions that he had the ability to override.
You're not going to contemplate my hypothetical then, Mr. Schroeder?
Because I don't think we're in that situation.
Okay. Since we're actually out of time, then I'll just thank you and ask if Ms. Foley,
yes,
Ms. Foley could respond. But thank you.
Yeah, I mean, it's a great and scary question. You know, if the president doesn't appreciate Congress's constitutional prerogative to make the law, and if courts aren't willing to defend that constitutional prerogative because of standing or whatever issues, or maybe Congress itself is too hesitant to even challenge the president in court.
Or if the president doesn't honor a judicial decision.
Or if the president goes even further and doesn't even honor a judicial decision. The bottom line, Jonathan is actually right, we're in tyranny. We don't have a constitutional republic anymore.
Thank all the witnesses and the chairman, and I yield back.